Hi everyone, I'm going to give everyone a minute to get in from the waiting room. Hi everyone, welcome to the webinar. I'm Christy Bagalow, the Director of Statewide Training at Florida Legal Services, and today we have a 30-minute webinar which is about the 2020 Family Law Legislative Update. It is scheduled for 30 minutes, but if we have lots of questions, we may go a little bit longer than that. And I'm delighted to have with us today Tenesia Hall. She is the Litigation Director and Senior Staff Attorney at the Legal Aid Society of the Orange County Bar Association. So thank you so much for doing this today, Tenesia. And I thought we had live captioning today, but I'm not seeing it on my screen. So I'm hoping maybe you can see it on your screen. If not, I will work on that as we go. I was hoping to test that out today and see how that works. So I'll be monitoring the chat box and the Q&A box during the webinar, and Tenesia has agreed to take questions during the webinar, so we'll try to get those all in during the webinar. I promise I did submit the CLE application about 6 weeks ago, but I'm still waiting to hear back. I think I have overwhelmed the Florida Bar with all of my CLE applications. So I'll send that out to everybody as soon as I get it, and I'll also send out the recording and the PowerPoint tomorrow. Thank you again, Tenesia, for being here with us, and the floor is yours.
Thank you. And just to follow up with the messages in the chat, no, unfortunately, the closed captions are not working. And then I'm going to be sharing my screen for a majority of the presentation. And I'm not sure if the closed captions will work there either. But Christy will be monitoring the chat to relay all of your questions. Feel free to interrupt me. I don't mind. All right, so now I'm going to go ahead and share my screen. Today we're here for the 2020 Family Law Legislative Update. During today's update, we will be addressing custody of minors by extended family member, domestic violence injunctions, domestic violence services, guardianship, and subpoenas. Unless noted otherwise, during this presentation, all of these amendments took effect on July 1st, 2020. Copies of all of the laws as passed by the legislature can be found on the Laws of Florida. The Laws of Florida is a good website that I found that is a verbatim publication of any general and special laws that the legislator passes or publishes in each given year. And I have hyperlinks in the PowerPoint, and just so you know, we're going to share this PowerPoint to everybody after the presentation. So as you go through, or as I go through, I'll show you what the links lead to, but you'll still have these links for your own reading after. So this will take you to the actual Laws of Florida for you to look at the bills as signed by Governor DeSantis. The first bill we're going to talk about is the custody of minor children by extended family members. This is Chapter 751 of the Florida statutes, and it pretty much affects all temporary custody and concurrent custody matters. In that, now extended family members are expanded beyond those related within the third degree to now anybody who has any type of relationship with a child, fictive kin. And fictive kin is defined in Florida statutes chapter 39. The bill is a bit lengthy. Let me show you. It's about 4 pages, and it talks about all the differences that are now going to take effect So for those of you who use the Florida Supreme Court approved forms, just note that the forms have not yet been updated. So for any Chapter 751 action you filed after July 1st, 2020, or if you're having a final hearing after July 1st, 2020, you're going to want to make sure that you can, if you need to, address the issues of extended family members, fictive kin, step parents, or anybody who has some type of familial relationship to the child. These individuals are now entitled to file for temporary custody or concurrent custody of that child. Additionally, with fictive kin, that can be a neighbor, godparent, mentor, teacher, anyone with a significant relationship with the parent or the child. The person filing for temporary custody or concurrent custody can now also request a transition plan. And that transition plan would include different things that would be needed to for the parent to take place before they could regain. I'm popping up your questions. Let's see. It would be different actions that a parent would need to take before they could regain physical custody of the child in question. For instance, if you are obtaining temporary custody or concurrent custody of a minor because the parent is homeless, then one of the things you're going to put in the transition plan is that the parent will have stable housing for at least 6 consecutive months prior to coming back in and obtaining physical legal custody back of the child. And I know it's kind of weird to use the phrases custody, but remember, since we're talking about non-parents and children, we're talking about custody and visitation. Whereas if this was Chapter 742 or Chapter 61, we'd be talking about parental responsibility, parenting plan, and time sharing. I see a question. So any fictive kin can file for custody. Yes, any fictive kin can file for temporary custody or concurrent custody, but remember, they still have to have physical custody of the child. And for temporary custody, you have to have the parent's consent, or their whereabouts have to be unknown, or they're deceased. And if their whereabouts are unknown, you still have to do the diligent search. And if they are deceased, you have to file a copy of the death certificate. It's also best practices when you're filing for temporary custody or concurrent custody to also file a copy of the child's birth certificate, as well as any certified court orders dealing with any parenting plan, time sharing, or child support related to that child.
Thanks for the great question and all the information on the answer, Tenesia. I did want to pop in and let everyone know that the closed captions are live. They're at the top of my screen, so hopefully you can see the red live box. And you can click on it, or if your security settings are set too high, you can always copy and paste the link and open it in a separate browser.
Okay. All right. So those are the major changes that have taken place with Chapter 751. Again, remember, once your concurrent custody or temporary custody order is signed and the parent comes back and requests to have that order vacated, then if the parties disagree as to whether or not the parent is fit and proper at that point, it then becomes a contested matter, and then Chapter 39 kind of takes effect, where they have to, the person trying to maintain custody of the minor has to then prove that the parent is unfit. Domestic violence injunctions. Chapter 741.30 was modified now to include pets. So in your domestic violence petition, as well as having stay away provisions for the petitioner, the home, frequently visited places, the petitioner's vehicle, you can now ask the court to prohibit the respondent from having any exclusive care, possession, control, contact, harboring, selling, or anything like that of the family pet, the household pet, a support animal for the petitioner, or the child in the petitioner's care. The actual order the actual language that should be in your order, and again, if you're using the Florida Supreme Court forms, they haven't been updated yet, so you want to cut and paste from the statute the information that needs to be in the order, that it can now award the petitioner the exclusive care, possession, or control of an animal that is owned, possessed, harbored, kept, or held by the petitioner, the respondent, or a minor child who is residing in the residence or household of petitioner or respondent. Now, the order will order that there be no contact with the animal. It will prohibit the respondent from taking, transferring, encumbering, concealing, harming, or otherwise disposing of the animal. And the bill does not apply to animals that are owned primarily for a bona fide agricultural purpose or to a service animal if the respondent is the service animal's handler. So in the petition now, when you're asking the court to award this relief for the respondent to not have any contact with the animal or to not sell, transfer, encumber, conceal, harm, or otherwise dispose of the animal, I think it's best to include in your petition a description of the animal, kind of like what you would have in a emergency verified motion for child pickup, where you state the child's height, age, or any kind of demographics. I would suggest in your petition that not only do you say that you would like to have exclusive use, possession, and control of the animal, but that you name the animal. If the animal has a name, you describe the animal or animals, so that when the order is signed and entered, you will have as much You'll have as much information as possible. Now, I saw another question that came through. Those are just links to my webinar and information about the closed captions. For domestic violence services, this bill actually took effect on February 27, 2020, where the Florida statute removed the Florida Coalition Against Domestic Violence from the Florida statutes. And then it now allows the Department of Children and Families to administer all programs related to domestic violence services. I have a question as to temporary custody. Are we requesting the conditions of transition in the petition, or is that later after the parent requests a temporary custody order to be vacated? My suggestion, and I think for due process purposes, it needs to be in the petition up front, that you would include in the petition what the proposed transition plan would be and how it's in the best interest of the child. And then also in the consent, I would suggest for best practices that you have that transition plan listed in the parental consents if you have them. That way it's in the petition and the consents. Because on the other end of the case, I get a lot of parents come in and say, I didn't know what I was signing. They tricked me. I didn't mean to give them temporary custody. And of course, this is normally after our clients have gone and applied for public assistance, and now they are going after the parents for child support, or there's an issue as to time sharing or visitation, whether the parent can just come and go with the child freely. And so now they're trying to overturn the temporary custody order or the concurrent custody order. So for best practices, I would include the transition plan in the petition, and I think it has to be in there now. And I would have the transition plan in the consents, as well as having it written into the actual order. That way it's 3 separate places, and the parties, everyone is on notice as to what the transition plan is. Because remember, ultimately the judge still has to approve it, since the standard will be in the best interest of the children. Another question, for possession of the animal in a DV case, do you need to plead or prove any danger or harm to the animal? No. You can now include the possession of the animal in the DV, in the petition, just as you would the possession of your home, exclusive use and possession of the home. There was another question which was then deleted. So are there any other questions? I know I'm going kind of fast. Any other questions about Chapter 751, temporary or concurrent custody of minors?
I don't see any other questions, Tenesia. I think the one that was deleted was the one you just answered. So
Okay.
all good.
All right. And are there any other questions about adding animals to the injunctions for protection or the domestic violence injunction for protection?
I don't see any. I think you answered them all. Thank you.
Okay. And then for domestic violence services, again, for those of you who have been contracted with FCADV in the past, you all should be in contact with your new contract managers through DCF. Everything is now through DCF, all of the forms. I've even tried to still access the FCADV website because they had some great resources on it, and those resources are gone. The website is just one page, redirecting everybody to DCF. For guardianship, there are a lot of different changes made to the guardianship rules. One of the changes was that, well, the changes were to ensure that the ward's personal and property interests are protected, including changes the way the do not resuscitate orders are obtained. So now, in the application for guardianship, as well as the annual plans for guardianship, the proposed guardian has to state whether or not they are receiving any remuneration in connection with that guardianship, with that ward, whether there was anything up front, anything expected, anything that occurred within the last year. In addition, they also have to now in the initial plan and all subsequent plans state whether or not there are any do not resuscitate orders for the ward, whether the order had been obtained, and if it had been obtained or completed at any hospital, you now have to fill out the date and the time, or the date and location for each of those orders, and the judge now needs to approve of all the do not resuscitate orders. And I want to say mostly that was because of a case we had locally in Central Florida, where we had a guardian or a public guardian that had a bunch of DNRs entered in a bunch of her guardianship cases against the wishes of the ward and without notification to family members. I want to say it was well within the 90s, like the 90 numbers for that. So the reminder is for your initial plan in each subsequent annual plan to include a list of all pre-existing orders not to resuscitate or pre-existing advance directives. Those also need to be included. The date an order or directive was signed, whether such order or directive has been suspended by the court, and a description of the steps taken to identify and locate the pre-existing order not to resuscitate or advance directive. And so what I did for all of my guardianship cases is I sent everyone a letter as soon as the law took effect, asking them about any of their DNRs or advance directives. It took a few of them aback. They hadn't thought about it or hadn't considered it, but I wanted them to know now. I don't want to wait until the time of the filing to file a report to find out that there were DNRs or advance directives, because the courts are really cracking down on this. I know we had this set for 30 minutes. I guess we figured we'd have a little bit more questions in there. So now we can take this time to go back through all the other questions. It wasn't a lot going on in family in this session. The temporary custody and the fictive kin took a lot. That was something that went back and forth between expanding the relationships for those who could seek services, as well as, what type of transition plan, what was the length of the transition plan. Those are all things that are being left up for the courts to decide. I foresee some litigation coming forward. We had some courts already implying or ordering transition plans before they return the child. It just wasn't a statute permitting them to do that as of yet.
Thank you for all that good information. That was very comprehensive in such a short amount of time. I did want to let everyone know that there's some more information on our YouTube page about the guardianship case that Tenesia was referencing, the big controversy with the guardian who did DNRs for pretty much all of her wards. So that's discussed in a recording by Roberto Cruz about guardian advocacy. So if you want to learn more about that, that's on the YouTube page, and I'll put that link here. And people are being shy. This is your chance to ask questions. Maybe they're saving them all for the next webinar, which I forgot to mention at the beginning. Tenesia, bless her heart, is coming back again very soon, next week, for another webinar with us about guardians ad litem in the dependency and domestic relations courts. And she'll be doing that with her coworker, Coravius Cohort. So thank you for doing that so soon after this one. That's on September 23rd at 2 o'clock, and I put the link in the chat box. And we'll wait a minute for questions to come in while I put that YouTube link for everybody. But if we
have
don't,
a raised hand from Leslie.
okay. My screen is so small, I cannot see that. I'll get to it.
Keep your hand down.
Oh, don't be shy, don't be shy.
Somebody else. Okay, 2 participants raised their hands.
Okay. Yeah, it's best when you raise your hand, it's easier just to put something in the Q&A box or the chat box. That's easier for us to see. That way we know what you need. I'll put a little reminder in the chat. Last chance for questions.
When do you think the Florida Supreme Court family law forms will be updated? I am not sure when they will be updated. I would say within the next, 2 to 3 months, possibly. With COVID-19, everything is delayed. I would say just keep checking back. But in the meantime, what I've done to all of my forms for temporary custody and concurrent custody is I've added in the transition plan language into the petitions, the consents, and the orders. And then for my injunction for protection forms, I've added in the language for the animals in the petition, the temporary order, and the final judgment. And some courts, some circuits are very proactive. So your local circuit may have already changed their forms to comply with the new statutes. Even if the Florida Supreme Court hasn't done it, your administrative judge, either in your domestic relations division or the overall courts, have probably already adjusted the forms for your case. Another question is, you referenced the need to list the steps to obtain the DNR. Why? I believe that's for the courts. They want to have all of the information needed because, let's see if I can pull it back up for you. And again, like I said, if you go into the link for the guardian advocacy that Christy referenced, what Roberto Cruz talking about, what happened here locally, it made the media. But if you go back, you'll see, like in that case, one of the clients objected to the DNR. He had a feeding issue where he needed to have, I think, something cleared in his throat ever so often. And if it wasn't cleared in his throat, he would have breathing issues. And so in order to help heal him from his breathing, he would have to have a surgery, or, or he'd have to have, I think, to be intubated or something like that, some kind of extraordinary measure. But it was all because of a feeding issue. And so with the DNR, they were unable to do that extraordinary measure. And so I believe he ended up dying because of that DNR, because he couldn't get, his throatway cleared out. And that was just an example. And then I think his family didn't even find out about the DNR or him being deceased for, I want to say, a month or two. Don't hold me to the exact time frame, but that was an example of one of the cases. But in that case, it was clear that the ward himself had objected to the DNR, but the guardian signed it and proceeded with it anyways. But, and then when they looked at that case, they looked at other cases. I do believe it was something like 93 cases in which that guardian has signed DNRs without providing notice to anyone. Because, even with if you want to resign as a guardian, you have to notify all the interested parties. In this situation, there was a DNR signed and no one had to be notified. And so the courts are now putting steps in place to, one, for the court to review the DNR and to make sure that it should be there, and two, to make sure that all interested parties are notified.
Wow, that's really disturbing. And the news report is in Roberto Cruz's Guardian advocacy video, so you can see a little bit more about the local media coverage of that story. And I think we've got a couple more questions. Can we go back to the guardianship slide? They want to make sure they got everything.
Yes.
So we will go back there, and everyone please send me feedback about the closed captioning and let me know how it worked if you tried it out. I've been experimenting with it, so I hope it'll be helpful. We have one more question. To follow up on the possession of the animals, do you need a specific and separate section like the exclusive use of the home in the body of the petition?
Yes, because remember, you need to identify what animal it is, because you can't just say pets, because you may have pets now, not pets then. You want to list them. You want to list the fish, the rabbits, the dogs, the cats, the parrots, the support animal. So you want to have as much specificity as possible in your petition in order to make sure that should you need, because I'm always thinking when you're drafting your petitions, you're asking the court for certain relief. And when you're drafting the orders, you're asking law enforcement in this situation to be able to enforce this order, or the judge to be able to enforce the order. And it always helps when you have as much identifying information about this pet and this animal as possible, and that you're including that it is not the support animal of the respondent, and that it is not an animal used for agricultural purposes. So for guardianship, this is the guardianship slide, and this has been emailed to you or added to the link. The actual law I included in a hyperlink for the bill is 7 pages long. And you'll see the words stricken through are deletions. The underlined words are additions. And all of this, because I know it's a lot. If I could really spend 30 minutes just reading the 7 pages and detailing it all out for you, but I included this in your materials. And then you can always go to each of these statutes. All of the statutes are now updated. You can find the statutes in your Lexis, Westlaw, but you can always access them for free at Online Sunshine. And all of them have been updated to include these changes. So right here in this section, this is 744.363, the initial guardianship plan. There is now a 1F where you have to include a list of any pre-existing orders not to resuscitate that were executed under statute 401.45 sub 3, or any pre-existing advance directives as defined by 765.101, the date an order or directive was signed, whether such order or directive has been suspended by the court, and a description of the steps taken to identify and locate the pre-existing order not to resuscitate or advance directive. And I always tell people, if you've had a ward who's been admitted to the hospital, a lot of times in their admission packets or their registration packets, they may ask you to fill out, an advance directive, or they may ask about DNRs. So if you have a ward who's been frequently hospitalized, even if the guardian doesn't remember if there's a DNR or an advance directive, they may be able to get that information from their primary care physician, or if they always go to the same hospital branch, like here we have Orlando Health or Advent Health. If they always go there, then there should be something on record. With the duty to file the annual guardianship report, you'll see here the annual guardianship report of a guardian of the property and the annual guardianship report of a guardian of the person must both include the declaration of all remuneration received by the guardian from any source for services rendered on or to the ward. And that includes anything indirectly, overtly, or covertly, or in cash or in kind to the guardian. It also talks about how, again, there's the pre-existing directives and the DNRs. And I'm just scrolling through for the additions. Right here, a plenary guardian or a limited guardian of the ward may sign an order not to resuscitate as provided by 401.453. When a plenary guardian or a limited guardian of the ward seeks to obtain approval of the court to sign an order not to resuscitate, if required by exigent circumstances, the court must hold a preliminary hearing within 72 hours after the petition is filed and rule on the relief requested immediately after the preliminary hearing, or conduct an evidentiary hearing not later than 4 days after the preliminary hearing and rule on the relief requested immediately after an evidentiary hearing. So from the moment that exigent circumstance arises until, 7 days after, all of this should be taking place. 7 to 10 days. I think since this is under 5, that is going to go by calendar days, business days, and not calendar days.
I don't know if everybody was able to see the screen. I think you have to stop share and start share again. But anyway, you can find everything at Online Sunshine. We did have one question about something that someone couldn't find at Online Sunshine, the updated Florida statutes for temporary relative custody.
Nothing is shown on the screen. Okay. So yeah, everything should be there. Let me look.
And I can send out a link later if we're not able to find it right now. What I'll do is send out a follow-up email tomorrow with the recording of the webinar so you can share it with anyone who couldn't make it. And Tenesia has agreed to share the PowerPoint with everyone. So I'll share that in PowerPoint and PDF forms. And that will also be where I put the CLE certificate when it moseys on over here.
All right, so online Sunshine, can everybody see my screen? Christy, can you see it?
Yes, now we can see it.
All right, so it's www.leg.state.fl.us. And it's just taking you to the Florida legislature. So what I did is I typed in 751.01 Florida statute, and it brought me directly here. This is showing the 2019. Let's see, I'm gonna scroll down to the bottom. It does not look like this one has been updated.
I'm putting the link to Online Sunshine in the chat for anyone who wants to peruse it later.
Yeah, this one hasn't been updated, but I know the statute, I believe on Lexis has already been updated. I don't know, maybe this is a delay because of the pandemic. But I have the rule, the actual law attached to your PowerPoint, so you should be able to access it that way. Or if you have Lexis or Westlaw. If you don't have Lexis or Westlaw and you need a copy of the full statute, just send me an email and I'll pull it and email it to you. My email address is tchall@legalaidocba.org.
And that's in the chat box.
So you'll see on the law 751.011 definitions now has subparagraph C, an individual who qualifies as fictive kin as defined by 39.01. And then I'm going back to Sunshine, and yes, it's not there. It's still showing 2019 statutes. So I think that may be a delay because of the pandemic. All right, so let's see what other questions we have.
I think that was it. And we will be sending the PowerPoint out tomorrow. Just got a few compliments in for a great presentation. And one person said it was so good, she didn't have any questions. So our job here is done.
I do have a question. Anonymous attendee asked, can we go back to 751? Do you need the parent's consent only when you file for concurrent custody? If so, is there an exception where you may have evidence to prove the parents are unfit, for an example, struggling with substance abuse? So for concurrent custody, do you mean, because the difference between temporary custody and concurrent custody is In temporary custody, you're temporarily assigning your parental duties over to the custodian. In concurrent custody, you are keeping your parental duties and giving the authority to the custodian to also have parental duties. So now all three of you can sign medical records or doctor's appointments, educational records, do school enrollment, so on and so forth. So for the anonymous attendee, if you have a parent with a substance abuse issue, is there a reason, well, not for this situation, you can call me afterwards or email me, because it may be better to do the temporary custody as opposed to the concurrent custody with a parent with substance abuse issues. But even in a concurrent custody case, you can ask for the transition plan. Consents are required, I believe, in concurrent custody cases.
Okay, thanks for all the great questions, everybody, and thanks for spending your lunch hour with us. Thank you again so much to Tenesia and the Legal Aid Society of the Orange County Bar Association for letting us borrow her for today and for next week. Hopefully we'll see you again next week for Tenesia's next webinar. Hope you all have a great week. Take care, everybody.
Bye-bye.